Well, hello, everybody, and welcome to the first episode of A Suit on the Roof, a podcast dedicated to roofing contractors with the intent of providing roofers with useful information on current legal trends, case law, and industry news and issues. I'm your host and the suit, Jose Rodriguez. I'm a partner and board certified by the Florida Bar as a construction law specialist at the law firm of the Soto Law Group based in Fort Lauderdale, Florida. Our firm dedicates itself to representing contractors, subcontractors, suppliers, developers, and owners in construction law litigation, including contract negotiation, drafting, employment issues, insurance issues, and litigating bond and lien claims. I want to take this opportunity to thank the Roofing Contractors Association of South Florida, also known as RCSF, for helping me to promote this podcast. And if you aren't already a member of RCSF, I really encourage you to become one. RCSF offers a lot of benefits to its members. One of those are monthly meetings where they provide their members with educational information on the same sort of things that this podcast is trying to achieve. Information on trends in the industry, legal issues, things that affect your bottom line as a roofer here in South Florida. In fact, RCSF has provided its members with ongoing information during the COVID outbreak, providing them with interpretations of some of the stay-at-home orders and what that means to roofers and their ability to continue to do work, and have otherwise helped their members navigate this current crisis with ongoing information and updates. RCSF membership has several benefits. Some of these benefits include discount on IT services, discounts on automated marketing services, discounts on sales training and coaching programs. RCSF also offers to its members legal services discounts and benefits. I encourage you to look at their website, review some of the membership benefits, and become a member of RCSF. So let me say this at the outset. Your form contract needs to be a living and breathing document. What do I mean by that? That document needs to be revisited regularly, every year. Because throughout that year, invariably, you're going to experience events and occurrences that you wish you would have been able to avoid, or that you've learned a valuable lesson from. And if you're not incorporating that into your contracts, then you're missing out on opportunities to better your business and opportunities to better your contracts. And this can be said for both contracts that you execute with homeowners, or commercial owners, and the same can be said with contracts that you sign with your subcontractors. So that being said, we're going to highlight some critical clauses that I think every roofer needs to consider. Now, there are many more, but within the limited time frame that we have, these are some of the ones that I've selected as worthy of today's discussion. The first clause I want to discuss is the force majeure clause, or what they call the acts of God clause. The purpose of a force majeure clause is to deal with project delays which have occurred as a result of events outside of the contracting party's control. Storms, disease. One perfect example would be the COVID outbreak that we are undergoing right now. And it's these sorts of events that this clause is meant to address. A well-drafted force majeure clause can serve as a safety net to overcome unforeseen events that will delay a job. Some well-known examples that you could look up on Google are force majeure clauses in the AIA General Conditions 201 or the consensus docs. Both of these documents provide sort of the standard industry boilerplate forms of a force majeure clause. Now, these types of clauses should be tweaked with more specific references that are relevant to your particular industry. A force majeure clause in a general contractor's contract shouldn't look the same way as a force majeure in a roofing contractor's contract. The key here is to take events that have occurred in the past and learn from them and incorporate them into your force majeure clauses. So, what event could you point to in a prior project that delayed the job, that wasn't in your control, and that you would consider including in a force majeure or an acts of God clause? A recent example from the past was when we were dealing with the steel tariffs. A lot of the steel suppliers were scrambling to see if their force majeure clauses in their contracts would cover such an occurrence. Many steel suppliers that we worked with, as a result of those tariffs, started including the specific reference of tariffs or a lack of materials as a result of government action into their force majeure clauses. So, what are some of the events in a roofing context that would warrant being included in a force majeure clause? If I were to think of an obvious example or an event to include in a force majeure, would be named storms, hurricanes. So the next clause I want to discuss are liquidated damages clauses. So a liquidated damages clause comes into play when the parties agree that the amount of potential damages will be difficult or impossible to prove. So the classic example is a developer's potential damages for late construction of a mixed-use project. So in a roofing context, you might find this type of a clause in your contract with a general contractor who is working with a developer on a large mixed-use project, and you're doing the roofs for this project. It's imperative to understand this clause and be able to negotiate it appropriately. One of the first things you want to make sure is that the amount of potential liquidated damages assessed per diem is a reasonable value, that it makes sense with regard to the value of your contract. In addition, and to the extent possible, you should try to negotiate a cap on the liquidated damages. I've had several clients that have actually been able to successfully negotiate a cap on their LD's exposure. And to the extent that you're able to negotiate that, that's a great win. You also want to make sure that if you're agreeing to liquidated damages, that is to a specific value of damages assessed per diem that a job is delayed, that you've closed the loop on what's known as consequential damages. Examples of consequential damages are lost profit, lost rents, lost financing, etc. So in order to close the loop on that potential exposure, you need to make sure that the contract has a waiver of consequential damages running in your favor. Most likely it'll be a mutual waiver of consequential damages, but you want to make sure that that protection is flowing your way. So the next clause in your contract or section in your contract that you really need to review are your insurance coverages. So within your contracts with an owner or a general contractor, you're typically required to have certain insurance coverage limits. You want to review these requirements with your broker and make sure that you're properly insured, properly covered for the particular project that you're involved with. So obviously there's going to be some considerations to take into account when you're dealing with more residential projects versus commercial jobs, but you want to make sure that you're adequately covered and that you have the right coverages for the particular work that you're involved with. So this is definitely a conversation that you need to have with your broker. The next thing that you really need to do when you're looking at your insurance clauses, insurance coverages, is review your insurance policy itself. What's in there? What are your coverages? What are the particular endorsements that are a part of your coverage? One of the biggest mistakes that I see, particularly in the roofing industry, is having endorsements that do not cover any damages when there is an open roof. It's called an open roof exclusion. There's really no reason whatsoever why a roofer should have such an endorsement in their insurance policy. So you need to review your policies, see what's there. Make sure that you're working with a capable and competent broker that is getting you insurance coverages that are applicable and protective of the work that you're involved with. Another item that you need to look at is, what are the insurance requirements in your subcontracts? So what are you requiring of your subs to carry on a particular job? In addition, are you requiring that your subcontractors have you as an additional insured on their insurance policies? This is critical. It's not enough to be a certificate holder. It's not enough to get a copy of their policy. You need to be a named insured on their insurance policy in order to be able to tap into that policy if anything were to go wrong on the project. Lastly, you need to make sure that in your subcontracts you have a waiver of subrogation. So any damages, any issues that would potentially be covered by an insurance policy need to be mutually waived as a claim against either the contractor, subcontractor, you, and your sub-sub. The next clause I want to discuss is your pay if paid clause. So these clauses were designed to shift the risk of non-payment by an owner to a general contractor, subcontractors, or sub-subcontractors. So in the event that an owner did not pay a contractor for the work performed, the contractor would have included a pay if paid clause in their subcontracts and would have shifted that risk of non-payment to its subcontractors. So as roofing contractors, you'd come across these provisions in your larger commercial or residential projects. The key here is twofold. One, to the extent that you can negotiate out a pay if paid clause, that would be great. Typically, though, when you're dealing with your larger general contractors, that won't be an option. So the key here is to make sure that you have that shifting of the risk flow down to your sub-subs or your suppliers to the extent possible. So if you find yourself typically working for your larger general contractors or developers, you need to really review your subcontracts and make sure that you have adequate provisions in there that shift the risk of non-payment by your customer / general contractor developer to your subcontractors. In addition, you want to be able to also have that pay if paid clause run to the benefit of any potential surety that may be involved. So on your larger projects, your general contractor may ask you or require you to issue a payment bond. Then you want to be sure that you have clauses in your subcontract where your surety can attach itself to those potential defenses. and raise a pay if paid clause as a defense to any potential cause of action raised by a subcontractor. Since we're on the subject of shifting risk amongst the particular parties that are entering into a contract, one issue that I want to raise is the idea of what items, what considerations, what events can you shift the risk back to the owner or the general contractor with which you're contracting with. So, by way of example, on a typical residential project where you're dealing with an owner, do you have something in your contracts that addresses the matter of existing water or mold damage? Do you have your crews trained to document, photograph existing water and mold damage? Let me tell you, how many times have I received a phone call by a roofer who's completed a job, the homeowner or owner then starts to assert that they didn't perform the work correctly, they didn't cover the roof adequately, and now as a result of that, there is water intrusion, water damage into the home. The roofer has no documentation, no pictures, anything to address this owner's claims and allegations. So an important item here to consider is, what can you do on the front end to document the existing conditions that are there? It doesn't take much to have some of your guys take a picture, document what the property looks like, what's the existing damages, and include in your contract a waiver, a release of any existing water or mold damage. In addition, you want to consider what items of real property of the owner do you want to make sure that you make them responsible for protecting. So, another example, if you're working on a high-rise condo, you're working on a homeowners association project, and you're dealing with wealthy individuals. People have nice cars in their driveway. They've got nice fixtures around the home. Are there provisions in your contract that require the owner to protect its real property or their real property? So if you're working on a house and the homeowner has nice vehicles in the driveway, are they required to cover them, put them in a garage, protect them in light of the fact that there's going to be ongoing construction at their particular real property? These are items that you really have to consider when you're putting together a contract and considering some of the provisions that you can include to shift the risk of liability or loss to the owner and not yourself. And then last but not least, there are certain clauses that you are required to have in residential project contracts by Florida statute. The first one is the buyer's right to cancel under Florida statute 501.025, and the second is the lien law disclosure required by Florida statute 713.015. These are basic requirements by the statute that require you to include standard boilerplate language in your contracts. You need to include them in your contracts. I say that because oftentimes my clients contact me and say, look, I've got a contract. It's too many pages. It's too long. What can we do to shorten that? One of the tools that I tell them they can use in order to shorten their contracts and not give their customers so many pages to go through is to include a provision in their contracts where terms and conditions that are found elsewhere, for example, on their website, there's a tab for terms and conditions to a contract. that are incorporated into the document that the owner signs. Now, you have to have the right language. You have to have the right mechanism to incorporate those online terms and conditions, and that's something that you need to discuss with your attorney and review that with an attorney. But assuming that you've done that, I've always cautioned my clients, don't include these two requirements for the buyer's right to cancel and the lien law disclosure on your online terms. I've always counseled my clients to include these two requirements, the buyer's right to cancel and the lien law disclosure, in the physical written document, not on their online forms. You can always include additional terms and conditions online, incorporate them by reference in your document, but it's imperative, I think, to include these two requirements on your residential projects in the physical document that the customer is going to sign. So in conclusion, I want to thank you for listening to this episode. I hope that you found it helpful and informative. I want to encourage you to please reach out to me with any questions, thoughts, concerns, ideas for future topics that you'd like me to discuss on this podcast. And you can send those questions, thoughts, ideas to asuitontheRoof@gmail.com. Again, that's asuitontheRoof@gmail.com.